we're actually here today to talk about a piece of legislation which is the biggest change in our industry in 37 years that is going to be coming into force in about 4 hours. Even today, I still, and the lawyers still, and the industry bigwigs still have grey areas in this legislation because it's the way that it is interpreted. It's different people's interpretation. There's still a lot of blurred lines and a lot of grey areas. So today, just please do bear with me. Because what will happen, and what happens with all laws really, is that the legislation is written, and then what will start to happen is case law through the courts, and that's how we will form our judicial decisions. I don't know if you guys remember, but back, I think it was around 2014, a massive court case called Superstrike v. Rodriguez, and it was all to do with deposit legislation. That was one of those cases that set precedent then for us with regards to deposits. So it is all new to all of us, but we do need to be very, very mindful. So without further ado, I am going to crack on. This is the biggest change in our industry for 37 years. I was talking with this gentleman sat here on the aisle earlier, and the biggest change that I'm talking about, he was actually operating prior to that, was in 1988 when the Housing Act was born. Now, when the Housing Act was born, it was a real positive for our industry. Because prior to 1980, it was actually the 15th of January 1989 it came into force. Prior to that, we were in a world of rent controls, in a world where you couldn't get your property back from tenants. Landlords would die before they got their property back because there was succession rights. So the change in 1989 was positive. And then there were some changes in 1997 that made it even better. But unfortunately, with this piece of legislation, it seems like some of the areas that they've implemented, that we're going back to some of those challenging times, particularly around rent arrears, that we were in 1989. So this is the biggest change to our industry in 37 years, and I am literally done with renters' rights. I have had to change every process in our business, every document that we use, everything that we do. It has been a challenge, but we're there. And they're bringing it in 3 phases. And good old government. Right, so what they thought was, phase 1, 1st of May, what we'll do is we'll load everything that the landlord needs to do in phase 1. Yeah? Everything that the landlords need to do, that's what we're going to put in phase 1. Anything that they've got to do, like create a property ombudsman for landlords, like create a database. Oh no, we won't do that yet. We'll do that later in phase 2. And phase 2 is expected late 2026, early 2027. Now, at my last seminar, I said, because it is the government and we're waiting on them getting ready, I thought it would be more so 2027 rather than 2026. However, I was speaking to one of our members, and she's actually trialled the database. So it is there, and it is ready. It's just in beta testing. So phase 2 is now likely to be at the end of this year. There will be a property database created, and every landlord will have to register themselves on the database, along with their properties, and all of the property information. So you see what they're doing here, don't you? They're making us visible. Now, this is already in force in Wales under a piece of legislation called Rent Smart Wales. Every landlord must be registered, every property must be listed, and all of your documents must be uploaded. So what that means is, you know, this £60 million the council have got to spend on enforcing this against landlords, well, they don't even need to leave the office because they can see if you haven't got what you're supposed to on the wonderful database. And of course, I'm sure the local authority will have full access to that, and tenants will have minimal access, or agents will have minimal access. But those are the 2 things in phase 2. Yes, end of this year. That's when we're thinking. So the database and the ombudsman is in phase 2, and it's predicted to be end of 2026, maybe early 2027. And the 2 things that are going to happen in phase 2 that will affect you immediately is it will be that requirement to register with a redress scheme, so an ombudsman. At the moment, letting agents have to do that. Landlords don't. I have to say I quite like the fact that landlords should do that, because do we have any self-managing landlords in the room? So for all of you guys, your tenant has no right to redress. They have nowhere to go to complain if you get it wrong. And whilst I believe you guys are good landlords because you're in a room like this, educating yourself, learning and looking at how we should be operating, let me tell you, there are a lot of landlords out there that are not. And actually, on one of our webinars, I can't believe that a landlord asked me, when did the deposit regulations come out? I wasn't aware I had to register the tenant's deposit. And I said, 2007. So they are out there. But so late 2026, we're going to be looking at phase 2, which are those two things that landlords will need to do. Unfortunately, they are going to come at a cost. And costs are rising for you guys as landlords. And if I had a magic wand, I would love to wave it to eradicate that, but I can't. And then phase 3, actually, it's no longer 2030. It's expected in around 2034. So we've got about another 10 years to worry about that. And that's all to do with decent home standards, AWAB's law, and the condition of the property. But do not forget that we already have at least, I would say, 4 pieces of legislation, if not more, that we have to comply with that is in relation to the quality of a person's property. So you have the gas safety regulations, the electric safety regulations, you have the smoke alarm and carbon monoxide detector, you also have the Homes for Fitness and Habitation, you have Section 11 of the Landlord and Tenant Act 1985, Consumer Protection Act 1987, all of which says you should maintain your property and make sure it's safe to live in. So that's why they've pushed the decent homes right the way back until probably another 10 years. So these are the things that are changing, okay? So these are the things that we're going to talk about today. And as of tomorrow, I keep calling it the new world because we've been in our old world for a long time. And tomorrow, it is going to change. So we're going to talk about stronger authority enforcement, periodic tenancies, the fact that Section 21 will be gone. We actually served our last Section 21 yesterday. The girls in the office, they were like, well, we probably actually served about 8 or 9 of them yesterday. But the girls were like, this is the last one we're ever going to serve. I'm going to talk to you a little bit about existing Section 21s. Do any of you have any Section 21s or 8s out there currently? Good, I'll talk to you about that. I want to talk to you about how we will evict tenants in the new world with the new grounds. I want to talk to you about the rent in advance restrictions because this is really important. The amount of rent that you can take, not only that, but also when you request the rent because that is a real key change that could cause a problem moving forward. I want to talk to you about the changes in rent increases because if your rent isn't where it should be, you will still have the right to raise it. They haven't given us a rent cap, although Rachel Reeves the other day announced that she thinks we should put a rent freeze on this year. Hopefully that won't happen. But there's new rules around rent increases and there's some important factors for you to bear in mind. Rental discrimination, rental bidding, and also rent repayment orders. Now, you see rent repayment orders for me is probably the biggest thing that I would be worried about as a landlord. Because a rent repayment order is something that can financially benefit the tenants personally. So not the local authority, not being enforced, it's they can claim up to 24 months rent back should a landlord fall foul of one of the pieces of legislation that allows them to do that. So as you can see there, that is a big fight. The rent's roughly around £950 in your area now. Let's round that up to £1,000. There's potentially 24 grand there on the table for them if a landlord does something wrong. And again, I have witnessed landlords that do things wrong. One of my colleagues, her daughter was living in a property, actually in Liverpool city centre. She was paying £1,000 a month for an apartment in the city centre. It was one of the older type buildings. And it was riddled with damp, absolutely riddled, to the point where she came to me and asked me for some advice. And I said, go to environmental health and get the council out. Now, the first thing that the council did when they came out was not just look at the damp, but they realised that this property was under selective licensing and it didn't have a licence. Now, that is one of the reasons currently now, not even in the new world, that a tenant can make a claim for a rent repayment order. And immediately she was in a position to take that landlord to court and claim back £12,000. Selective licensing, so in this area, it's in Sefton and it's in Liverpool. Is it also in the Wirral or no?
No, it's not in the Wirral, but it is parts of over the water.
Over the water?
Yeah.
I don't know what that means.
Wirral, like parts of like Wirral, Birkenhead ways.
So a selective licence is basically a scheme that the local authority can choose to operate in certain parts of a borough of the council. And what the properties that they choose, the area that they choose, every property in that vicinity will need to have a licence, regardless of whether it's a one-bed flat, a two-bed house, three-bed, it has to have a licence. And Liverpool actually are on their second go-around, aren't they? They brought it in 2015. That was a nightmare for us at the time. Ran it till 2020, didn't give us a single licence because they got it wrong and they didn't selectively licence the area. They licensed the whole borough and therefore had 55,000 applications fall on their desk and they never actually issued a licence. But that came back into force, Alicia, what date, what year, 2022?
Yes, I think that was for Liverpool, and then Sefton was a year later.
And they're in for 5 years. So anybody that rents a property in an area that is selective licence needs to have a licence. And that is one of the things under the rent repayment orders. So it's really important we talk about that.